Disparate impact is when neutral non-discriminatory policies or practices that treat people equally still leads to disproportionate results. That is distinct from disparate treatment, which is when the law, policies, and practices, as they're actually written, treat people differently because of protected traits such as race and sex. The problem is when a policy is non-discriminatory in its intent and application, but still leads to undesirable racial or other politically uncomfortable outcome or disparate impact. For example, the Fair Housing Act of 1968 bans discrimination because of race, color, and sex, among other traits, during home sales, rental arrangements, or housing-related financing. However, landlords, brokers, and lenders are still free to consider other factors such as criminal records and credit history. Under disparate impact theory, unlawful discrimination is presumed if a landlord rejects applicants because of poor credit and that race-neutral practice results in, for example, less Hispanic applicants being approved. To avoid disparate impact liability, landlords and lenders might therefore eliminate or water down reasonable standards if those standards have a disparate impact. Or take, for example, a situation in which non-discriminatory discipline policies for school misconduct result in more Black children receiving detention than, say, Asian children. A disparate treatment analysis might suggest that Black students are misbehaving at higher rates than Asian students. However, a disparate impact analysis would presume discrimination, making a school district liable for civil rights violations. Unfortunately, disparate impact can encourage covert entities like schools to adopt covert quotas, which are themselves discriminatory, to ensure they achieve a racially balanced outcome. So, instead of addressing an imbalance in misbehavior rates, schools are perversely incentivized by disparate impact theory to excuse classroom disruption on the basis of race. Ironically, in the context of student discipline and crime, those hurt most by disparate impact theory are other students and neighborhood residents, most of the same race, who want to learn and who want to live in safety. Disparate impact advocates claim that to truly provide equal opportunity for everyone, especially for those who are disadvantaged, it's important to directly address persistently disparate outcomes. Moreover, they claim evidence of discriminatory treatment is difficult to uncover, and the Supreme Court has approved disparate impact analysis when a law has effects-based language. For example, a policy adversely affects someone negatively on the basis of their race. Disparate impact opponents argue equal opportunity requires the elimination or at least diminishment of barriers, such as race discrimination, to participate in government, business, and civil society. That the effort to make outcomes equal requires authoritarian and discriminatory measures that cause more harm than good. And that disparate impact theory turns our civil rights laws on their head by essentially requiring practices, such as establishing quotas, that are exactly what the law prohibit. Both sides assert that their theory is the only way to achieve justice and fairness. Join the conversation in the comments below.